to setting up business in Singapore, the things we should consider, and what the decisions we should take when we are thinking about doing a business in Singapore. Before we start, let me please give you a couple of information about our Chamber of Commerce. We are a very new Chamber of Commerce. We were established just a couple of years ago. The objective of the Chamber of Commerce is to promote the business relationship between Singapore and Spain, and also to help our members to do their business in Singapore. We are an official Chamber of Commerce, which means we are recognized by the Ministry of Trade and Industry in Spain. And we act as a consulting agency of the Spanish government. Among our members, we have some of the biggest Spanish companies that they have their office here in Singapore, which some of them, they are also worldwide leaders in their respective sector. We are also member of the network of the Eurocham in Singapore, and also member of the network of the Spanish Chambers of Commerce worldwide. We are about 75 Chambers of Commerce everywhere. About the webinar, the objective of the webinar is Helmsman to share with us the key points that we should keep in mind when we are considering setting up a business in Singapore. I want to thank Helmsman, which is a member of our Chamber of Commerce and also one of the most prestigious law firms in Singapore. Before we start, let me give you just a couple of practical information about the webinar. We're going to have two speakers, and at the end of the presentations, we will have some time for questions. So you feel free to send your questions by the chat, or you will be able also to ask the question directly to the speaker. Another practical information, we are going to record the webinar, and they will be available in the YouTube account of the Spanish Chamber of Commerce. And now, without further delay, we're going to start with the first speaker. Let me introduce you to Lynette Ko, Director of Helmsman. Lynette's expertise is in corporate banking and finance law. Before joining Helmsman, she was head of legal and business administration at Mithuo Bank, in charge of corporate banking business in Singapore and in the region. Lynette has deep expertise in the funding needs and structures across a wide spectrum of industries. She has worked on the full range of commodities and trade financial transactions with major trading houses across the world. Lynette also spent a decade as a litigator specializing in banking and financing disputes, corporate insolvencies, and debt restructuring. So thank you very much, Lynette, for your participation, and the floor is yours. Thank you.
Just give me. Hola a todos, me llamo Lynette. Soy abogada del bufete Helmsman en Singapur. Hoy, con mi colega Matthew, nos gustaría compartir sobre lo que debe considerar cuando establezca o haga crecer su negocio en Singapur. De ahí hablaremos sobre algunos problemas recientes en la ley laboral aquí. I hope you could understand that. And now I'll just introduce ourselves in English. My name is Lynette, and I am a director with HELMSMAN. It's a law firm in Singapore. Today, I'm with my colleague Matthew, and we would like to share with you the considerations that you should bear in mind when you want to set up your business in Singapore. And after setting up, I think something that people don't really pay attention enough to is how you grow the business, the challenges that you face, and as the business grows, perhaps you may face some insolvency concerns, especially in the current climate of COVID-19. And thereafter, we want to talk a little bit about employment law in Singapore, because this is a space that I think many people are concerned about now, especially, what are the requirements? What is the Singapore government's outlook in terms of talent and foreign talent and recruitment of foreigners into Singapore to work? So just briefly, this is what we will share with you about today, the life cycle of business. When you set up, the things you need to think about. When you grow the business, what things could potentially be on your mind. Then we talk about insolvency concerns, employment issues, and we go into the Q&A. So the first thing we do is to look at the life cycle of a business, right? I think people give a lot of attention to starting a business, and when things don't go well, or when the business stops, the things that you should think about. But we also wanted to share with you a little bit more about growing the business when you talk about things like acquiring parts of other people's business, or when you grow and you actually start to need funding. So I think one of the questions that we commonly would face is, for example, Lynette, I want to set up a business in Singapore. What kind of legal structure should I take into account? And it's always very confusing. People will usually give you a standard answer like to set up a company, but that's not necessarily the correct answer all the time. Now, I start first with a representative office. And why is that so? Because before you decide whether you want to penetrate into the Singapore market or Singapore and around the region, because a lot of companies have their regional headquarters in Singapore, you want to know whether it's easy to set up business here, what the market is like. Maybe you want to study competitor behavior. So you don't want to set up a full business, but you want to be able to get some viewpoint about what the market is doing. Now you can set up a representative office here. This is not a separate legal entity from, it doesn't have its own legal independence. It is joined to your parent company or your headquarters, let's say in Spain. And all it can do is really just to do market surveys and study behavior. It can't drive any revenue. So the use is quite limited. Now, of course, if you decide that you want to enter into that market, the next thing then to consider is, what shall I do then? Should I set up a branch office or a separate subsidiary company? The answer depends on really what you want to achieve, what's your structure, and the obligations that come along with it. When you set up a branch office, you can only do the same activities as your parent, okay? And because it's not considered a separate legal entity, the tax incentives are also different. You will not be able to enjoy the local tax exemptions or the benefits that the Singapore government gives to Singapore companies, right? But however, having said that, the reporting obligations to the Singapore authorities and regulators is a lot less, right? And that will show up when I talk about what happens when you set up a separate company like a subsidiary. So to add to the confusion, and actually it's not that confusing, as a subsidiary company is really what I have shown in the slide. That is a limited liability company, and in Singapore it's commonly what you do. You incorporate a company, a private limited company. Being a Singapore incorporated company, the reporting requirements are a lot heavier. The cost is also more. There are more obligations in terms of like directors and all of that, which I will share with you in a bit. But the thing is that you have a separate legal status. So the thing about the advantage of it is that there is a separate legal entity, and if anything goes wrong and the company gets sued, you can't touch on the assets of your parent unless certain exceptions apply, like fraud and all of that. But in the ordinary course of the business, whatever is put into the company and whatever the company incurs is just kept there. I will explain a little bit more about the reporting requirements in a bit. We have gotten some queries where people are curious about, besides a company, what about a partnership? What about a sole proprietor and all of that? Now, it's very hard to explain in great detail within this short time what structures you should adopt. So I can only give you the basic guiding principles. And of course, if you have any questions, feel free to ask later. So a sole proprietor, it's really like if I want to set up an online, a cake shop, for example, right? There is no separate legal identity. It's really just me, and everything that I put into the business and all the liabilities that the business acquires is really mine. So it's usually a very small setup and not very common for businesses, that are, I guess, coming inbound and trying to set up a big outfit. Now you have a partnership, and this is a similar. It's not, there is no limited liability status. So whatever the partnership, let's say two people come together to set up a business, whatever the partnership incurs in terms of liabilities, that really is all of yours to bear. There is no there's no ring fence in terms of the structure as compared to a limited liability company. Limited partnerships are a little bit more different. You usually find them in certain professions and in asset management houses like funds, where you have a general partner and a limited partner. And usually one runs the business and the other one is the one that funds the business. But there again is no separate legal status, and therefore the liabilities of a limited partnership sometimes can go beyond what you have put in the company if it's not doing well. The limited liability partnership is a little bit different. It is a separate legal status. And then some people may ask, what then is the difference between a limited liability partnership and a limited liability company? A limited liability partnership, usually when you want to sell the business, each partner has to sell their business, as opposed to a company which is sold as a whole. So I think for most businesses who want to come into Singapore, unless there are special reasons, usually you would have a limited liability company structure. Now, I want to talk a little bit about the documentation that you should consider. Again, like I said, within the short frame of time, it's not possible to go into details. But there are certain businesses that come in and they want to sort of combine with a local partner who knows the market better, perhaps. And they are the one who want to bring in the know-how. Now, before you actually decide what structure you want to adopt, you may need to actually discuss very sensitive material or information that you don't want the other party to walk away and use in the event that the discussions don't work. So what people often overlook is what we call a non-disclosure agreement or confidentiality agreement. Now, this is important, especially I think in today's age where everything is quite global and people can very easily use ideas or customer lists, whatever sensitive information you have. So one of the things we always advise is to sign a non-disclosure agreement before you start to talk in terms of profits, numbers, know-how, customer lists, and all of that. And once you have decided that, okay, this is something that we can do, then what kind of structure or what kind of legal documentation do you need? There are various forms. It can be a shareholders agreement, a partnership agreement, a joint venture agreement. The uses of these are quite individual. Like a joint venture usually is for a specific purpose, a specific project. But we will actually need to study the details before we can advise what is the best structure. For a lot of companies that are starting out quite small, the number of staff or number of employees they have in Singapore is going to be quite small to start with before the business actually grows. And commonly, you can have a shareholder or a director in a Singapore company, and the common arrangement in the first few starting out years is for them to actually pump their salary back into the company. So how it works is that they actually lend that money that is their salary, and they lend it to the company with certain specific terms. So one other document that is commonly comes into play is your shareholders or directors loan agreement. This needs to be drafted properly to ensure that the company and the individual director or shareholder is properly protected, because they are not receiving their salary as and when it's due. They're actually putting that money back into the company. Now, I mentioned earlier that if you set up an incorporated company in Singapore, that there are quite a few provisions that you have to comply with. There are a lot more than what I've written, but I think what I have put there are the key ones that you want to bear in mind. So for example, in a limited liability partnership I mentioned earlier, there is no need to appoint a corporate secretary. But when you have a company, that is a requirement. You need to have a Singapore registered address. You need to have a Singapore resident director. That means somebody that's living in Singapore for tax purposes, and that's usually about half the year as I understand it. There are annual compliance requirements that have to be met. You have to have an annual general meeting every year. There are certain returns that you have to be filed with the authorities. And of course, everybody has to pay tax. That's a universal truth. So I want to talk a little bit more about resident director. There are certain companies that they don't really want to have a director located in Singapore. So commonly what is done, there are companies that provide these services where you have what you call a nominee director. That's a person that's living in Singapore already. And for the purposes of fulfilling the requirement of a locally resident director, you perhaps enter into an agreement with them, you pay them a certain fee, and they are going to be the one actually sitting in Singapore and fulfilling the requirement of a locally resident director. So let's move on to starting a business. And I think this is something that's important to bear in mind. That's about your employees, right? Human capital. Whether you're a startup, a fintech, whatever it is, you're going to need people that are working for you. And I explained earlier that employment law is something that is moving quite fast. There's quite a lot of changes in Singapore. So Matthew will share a little bit more later in this webinar about employees. So I won't touch on that for now. And the next thing you want to bear in mind is vendors and suppliers. Of course, depending on your business, if you're in a bank, you still need vendors. If you are in the F&B industry, you have suppliers of your fresh food, for example. So no matter how small a company you are, you will always need vendors. Your data service, for example, your IT people. These are usually vendors, and depending on your setup, you may need office space. So you have your office tenancy agreements. So these are the legal contracts that you need to bear in mind. And what I wanted to share about is about protection against COVID-19 risks. So in Singapore right now, I think because of the situation, the government has been giving landlords certain grants which they are supposed to pass off to their tenants in specific industries to offset the losses that they have to incur because they are not able to carry on their operations. However, besides that, what we would say is that if you do have to take up office space, for example, you should actually ensure that you read the contractual terms properly. For example, if the law prevents you from going to the office, can you negotiate with the landlord for it? When the office is empty, do you still have to pay rental? Ordinarily, you would have to, but if you can include certain protection inside your tenancy agreement that allows you to extend the time that you're not physically in the office, that would be ideal. Okay, this is all a matter of negotiation, of course, but if there is something, for example, some landlords tend to be quite heavy in terms of their terms, such that you are locked in for 2 years, and if you want to break the contract before 2 years, you still have to pay the rental for the rest of 2 years, even though you have broken the contract. So there is in law, obviously, that you need to try and look for a new tenant, but the thing is that if you can try to avoid that situation when you're negotiating your tenancy agreement, that is certainly something that you should look into. Now, customers, in any business, we all have customers. So depending on your industry, there would be different customer agreements that you would have to look into. What I want to focus a little bit of time on is personal data protection policy, which not many people place emphasis on. If you actually see the world that we live in today, there's so much personal data that is up there in the cloud, that companies are storing. Now, Singapore has a fairly strict data protection law, and what I want to share is that it's not about whether your company will have a data breach. It's more about when it happens. Why I talked about preparing for a data breach is that most companies that set up, usually when they go to somebody that helps them to start the company, they will have a standard data protection policy that people don't pay attention to and they just sign off on. Now, in Singapore, you need to appoint what you call a personal data protection officer. That is mandatory under law. And the consequences of a data breach can be quite stringent. So you can be fined up to 1 million Singapore dollars or 10% of your annual turnover, whichever is higher. So this was quite recently amended. And whilst I understand a lot of European companies are already subject to GDPR, please bear in mind that the GDPR and the PDPA, that's the Personal Data Protection Act in Singapore, are not the same. So there are similarities, but there are differences as well. So what we would actually advise is when you set up the company, do have someone pay attention to the contents of your data protection policy, as well as to have a protocol or a management plan, what happens. Why I say this is because, like the GDPR, there is a time-sensitive requirement to do reporting to the authorities in Singapore when there's a data breach. That's 72 hours. Now, not only must you report, you must also inform the persons whose data has been taken in the breach. So there are many things to do. And you can imagine that when that happens, you'll also be calling your vendor, if it's not internal, to basically either lock down the system or whatever it is to prevent further access by the hackers or these people who have illegally accessed the data. So there are so many things to do. And trust me from experience that you're not going to be able to cope when it happens. Now, if you're in a business that is very highly customer-centric, where you collect, like the birth dates, or whatever it is of your customers, now that is personal data. And that is always the question that is going to cause people a lot of concern. There have been recent data breaches in Singapore, in the healthcare, in a university, and all these are very, very recent. So this is something that I think people don't pay enough attention to. Please do bear this in mind when you actually start your business. Now we move on to growing the business. And this is something that, is not heavily touched upon because it really is dependent on what is happening in terms of your growth. One of the things we want to share about is mergers and acquisitions. If you want to acquire the part of another business or, a specific asset in the business like machinery, or it could be a client list, whatever it is, right? Again, the confidentiality agreement, that is very important because if it does not work out, people are going to walk away with that information, which is so important to you and it's actually price sensitive, for example. So we advise again, please have a confidentiality agreement before you start talking. Okay, I mean, cash flow talk is fine, but once you start talking about numbers, about data and all that, confidentiality agreement should be in place. Now you can purchase the shares of another company or an asset purchase, as I mentioned. Recently, we did an acquisition for a client, a European client. And what I wanted to ask everyone to bear in mind is about the merger control assessment. I think during COVID-19, you see a lot of sort of businesses actually consolidating, and you're in the same industry, but not exactly. And then you think, okay, I'm going to buy this part of business to supplement or to make sure that I can service my client on a bigger range, right? So that the client is it's going to stay with me and not go to someone else for something else that is I can actually do. In Singapore, you have competition law, and the law again is quite strict. The trouble is that it's not, you are not told whether you need to make a sort of like a declaration prior to the merger, because that is a self-assessment. The thing is that if your assessment is wrong, then the regulators are going to come after you, right? So this is something that you need to consider as well, because I think what the government is not just in Singapore, but everywhere, they're concerned about market monopoly and market manipulation, where you're able to control a market. So this is something that please keep in mind when you actually start growing. Next, we talk about franchise licensing agreements, referral agreements. I don't plan to go into detail because these are all dependent on whether you're going to acquire a product or a business, a service. But what I want to share again, and you find that I keep repeating on this point, that's only because we see things happening in this space. Protection against competition, right? So if in the event that the franchise is terminated, for example, does that put you totally out of business? Before you actually went into the franchise agreement, you were already doing something that in that same industry. This is something you need to pay attention to, which usually when we do business, we are concerned about the pricing and all of that. But do bear in mind, you don't want to be kept out of that industry if things go wrong. So always study the anti-competition clauses, how long you can't run the same business, etc., after the agreement terminates. I want to talk a little bit about funding because obviously, my experience is in the banking industry quite a fair bit. I'm not going to talk about venture capital funds because that's a totally different topic that we can't cover here. But we talk about your traditional sources of funding. So if you actually go and borrow money from the banks, what you would have to look into are like loan agreements, facility agreements, and sometimes, especially in the current climate, banks may require you to put securities with them. That could be funds, and that's very simple, like a deposit. But when you talk about a mortgage, a guarantee, those are things that you need to study properly in order to ensure that the bank, as you know, usually it's quite one-sided, those contracts. You want to make sure that you can get it to be more balanced. I'm not saying that the banks will agree to it, because having been in a bank myself before, I understand how these things work. But you want to try to get something which is a lot more balanced in your favor. Now, one of the things that people don't like to talk about is insolvency, right? It'll just talk about profits and growing the business. But I think this is something that is necessary to share, especially with COVID-19 and how the global outlook is. So I'm going to pass the time over to Matthew to share more with you.
Hi everyone, I'm just going to swap my screen so I can start sharing. And then we will go. Okay, so thanks Lynette for that. And now we're moving into the insolvency concerns. So while you've grown the business, you've set up a good structure, you have your contracts in place, you have funding, and then you start running into problems. And this normally first relates to problems with a counterparty. So you've been trading with this counterparty for a period of time, and you realize that the counterparty has been late in paying its invoices, or they keep asking for you to grant them credit terms. And finally, you hear news that they are going down. So what does a company do to protect themselves in this situation when the counterparty is going insolvent? So I've been a restructuring insolvency lawyer for close to 10 years. And really the first and most important thing to do is always to monitor your counterparty. Now, there are various ways to monitor. Obviously, if you're in a specific industry, there are industry newsletters or market news blogs, sites, which tend to pick up, right, on issues faced by companies. For example, in the oil industry, or in the shipping industry, it's very common to have very industry-specific market news sites, which will then share whenever they hear whether a ship owner is going down, or a charterer is going down, or an oil trader is going down. Another good source of market information is actually
sorry,
how does
Matthew.
this work?
Sorry,
Banks
Matthew.
normally have in their protections,
We cannot
in their
see.
contracts,
We cannot see the
many
screen.
protections.
Oh, you need to share the screen.
Oh, my screen is not being shared. Sorry.
Thank you, Fernando.
Sure.
Resume share. Okay. Right. Screen sharing. Good. Thanks. Okay. So, yes, banks. Banks normally have provisions in their contracts to monitor financial ratios of the companies they are lending money to, and they tend to be able to pick up problems with companies much faster than a normal counterparty who's just simply trading with them. In fact, I've been seconded to a bank before, and I can safely say that they have a separate division in their restructuring and insolvency, and basically a bad debts department, where their job really is just to monitor the news on a day-to-day basis to ensure that their clients are keeping up with their payments and have not entered into any situations that will cause their credibility to deteriorate. So one of the signs that you can always tell is when a bank pulls its financing facilities, or when your counterparty all of a sudden, without any explanation, manages to refinance their loans, which are not due yet. It may be because this current banker is not confident of the company's profitability moving forward. Obviously, as a trader or as a company doing business, monitor your repayments from your clients, whether they are often late, and then if they are late, what's the reason for it? Are they facing credit crunch issues? Make sure that you are able to be in a position to react when you know that they are going down. And so that leads to my next point. What do you do when you realize that your counterparty has some liquidity issues? Well, the first, of course, is to reduce your risk and exposure. You would like to cease your credit terms if you are dealing with them on credit terms. Perhaps you can just insist on moving on cash on delivery of services or goods moving forward. So that's in terms of the amount of money that they will owe. You can also reduce the volume of trades with your clients or your counterparties to ensure that at least you can manage any risk of a counterparty going down. And the last point about counterparty insolvency is really this is the time when you go and look at your contracts governing all the trades that you're doing and test whether your lawyers have been good in protecting you and your rights in the situation that a company goes down. So the first thing you should do is always review your existing contracts, see if you have existing obligations, whether they can be terminated, right, for breach, or whether you are allowed to suspend deliveries for the period of time for which you are unpaid. Now, these existing rights and obligations are very important. Sometimes it may make sense to continue a relationship with a counterparty who's going down or who may at the moment only be facing a little bit of liquidity issues. And so you decide, I'm going to continue trading with this counterparty. Please ensure that the new contracts that you enter into provide for security and a way for you to get out of the contract if the payments stop coming. So this is the situation when you realize your company or your counterparty is not doing well. What happens when the counterparty really reaches the stage where it cannot continue business? What happens in that situation? Now, restructuring and liquidation in Singapore is a very big area. Just for some background, Singapore used to be a very pro-creditor regime in that creditors had a lot of rights against debtor companies when it came to restructuring and liquidation processes. However, that has now shifted in the last 5 to 10 years. We're actually moving towards a more pro-debtor regime. If you're familiar with the US Chapter 11 bankruptcy regime, you realize that the US Chapter 11 regime provides a lot of leeway to the debtor to propose a restructuring plan, protections to the debtor. Singapore has, in the last 5 years, actually adopted a similar approach. In fact, last year, a new bespoke Insolvency, Restructuring and Dissolution Act came into force, right in the middle of COVID. Prior to that, there have been talks about having this dedicated Insolvency Act for about, I think, close to 10 years or even more than 10 years. In fact, since I was in law school, we were told that this new Insolvency Act was coming up. That was close to 15 years ago. And it finally did come out, and it was finally came into force in July 2020, right in the middle of COVID. So what is Singapore trying to do? It's trying to actually position itself as a restructuring hub in Asia. It wants companies from the region to come to Singapore to restructure their companies, thereby giving business to insolvency lawyers, insolvency professionals like accountants. And how did they do that? They did that by revamping their restructuring laws. Singapore has basically two main restructuring mechanisms: scheme of arrangement and judicial management. Now, these are basically court processes where a company can utilize the services of the court, make an application, and then follow through some statutory procedures and get its creditors to agree to either give it more time or to have a proposal to get out of insolvency. So the key thing about our restructuring laws, both for the scheme of arrangement and the judicial management mechanism, is that there is a moratorium in place. A moratorium basically is a court order preventing creditors from taking action against the debtor company for a period of time. And this can extend to simple things such as, you are not allowed to sue the company during the moratorium period. But in recent years, the government, or basically the legislature, has extended this protection to even enforcement of security. So it used to be the situation that if you were a secured creditor, you wouldn't really be concerned if a company tries to restructure or goes into liquidation, because you can always enforce your security, and if your security value is greater than the value of the debt, you come out in a net position. However, with this new laws in place, and if the company manages to get a moratorium, it prevents secured creditors from enforcing their security. The purpose of this obviously is to give the company some breathing space during this period of restructuring. But because of our push to make Singapore a restructuring hub, the law has also made it clear that the threshold for applying for protection in Singapore is actually quite low. You need basically a connection to Singapore. There are various factors which will point towards the company having a connection to Singapore, but it could be as simple as having contracts which are governed by Singapore law, or especially financing contracts with banks which are governed by Singapore law, or property in Singapore. So that is quite a low threshold to cross, especially when the debtor company has presence in various jurisdictions, trading with companies in Singapore. So between the scheme of arrangement and the judicial management, what really is the difference between these two? What are these procedures? Well, as I mentioned, they are both restructuring mechanisms, but the key difference between the two is that for a scheme of arrangement, the company remains in charge. So the director remains in charge. There's a scheme manager, basically a person who will be proposed to implement the scheme, but the directors remain in charge of the company. For a judicial management, however, a third party comes over. An independent third party comes in to displace the management of the company. So the difference between these two usually results in creditors thinking, which is better for me? So if a creditor believes that a company has been engaged in some fraud or mismanagement, they would prefer to have an independent third party come in to take over the company and run the restructuring process. So they will go for judicial management. But if they believe that the company is, a trustworthy company, is simply that they need some time to restructure their debts, need some breathing space, then they will be amenable or open to a scheme of arrangement where the company directors remain in charge. Another difference between a scheme of arrangement and judicial management is that under a scheme of arrangement, you can actually have a cram down of dissenting creditors. So to put it simply like this, under a scheme of arrangement, you must classify your creditors into different classes depending on their rights. So for example, a secured creditor will be in a separate class from an unsecured creditor. And unsecured creditors, they themselves may be split into various classes depending on how much they are going to get under the scheme of arrangement. And so when you have these different classes, what happens is that if you have a majority in number, representing 3/4 in value of the total debt owned by those creditors, you can actually cram down on the other creditors who dissent, who disagree or vote down the scheme. So basically, if you have a 75%, if a majority number holding 75% of the debt, and they say, for example, the remaining 25% of the creditors, they disagree, right? You can actually force them to, for example, take a haircut, which is actually referring to take a reduction in amount of debt owed, or force them to take for example, a debt to equity swap, or maybe to extend the repayment terms. So all this will actually come into play in a scheme of arrangement, but that's not present in the judicial management regime. So after you see these restructuring processes, sometimes the business is over. There is no way to resuscitate a business. That's when the company goes into liquidation in Singapore. Generally, as a creditor, you don't really have a lot of control over that stage because it's run by a liquidator who's appointed either by the courts or by the company. And at a point of time, your only interest really is to file something known as a proof of debt in the company's liquidation, so that you will notify the company or the liquidator that you are owed this sum of money. And eventually, when the liquidator manages to realize the company's assets and has value, it can actually distribute monies to all its creditors. So there are two types of liquidation in Singapore. You have the court-ordered liquidation and you have voluntary liquidation. The difference really is that when the court-ordered liquidation, it's someone forcing the company to go into liquidation, probably because the company refuses to put itself into liquidation, because the alternative to that is voluntary liquidation. The company can itself decide that it cannot continue to go on business, and it knows it's insolvent, and then decide that it is going to wind up its business. And then it can, of course, nominate a liquidator, but the final say of who the liquidator will be is controlled by the creditors. So in general, it's roughly the same process for court-ordered or voluntary liquidation once the company has gone into liquidation. Just that, for court-ordered liquidation, I think liquidators have slightly more powers, and there's really a greater oversight by the court, because in this case, it's quite clear that the company itself, has refused to put itself into liquidation. So now I'm done with insolvency issues. Let me share with you more about employment. So I think Lynette spoke at the beginning that employment itself, it can be a huge issue for companies. How do you decide how to staff your companies? As a foreign company coming to Singapore, what do you have to think about when you decide to start a company in Singapore and really start a workforce? So the first broad point is hiring. You're going to start building a workforce. Now, Singapore is an at-will jurisdiction. This means that generally employers have the way to say, you can terminate an employee at will. However, we do have various protections really provided by the Employment Act and the Common Law of Singapore. Traditionally, again, the employment regime used to be pro-employer in Singapore, but in recent years, more protections have been afforded to employees. In particular, for example, the Employment Act only used to apply to employees who earn less than $4,500. So, all your executives and managers earning more than 4,500 Singapore dollars, they were excluded from the operation of the Act and all the protections that it had. But I think in the amendments made 2 years ago, the Employment Act now applies to basically all employees in Singapore. And that means that all the protections there apply to almost all your employees, save for a specific portion of the Act, which really deals with lower income workers, and they deal with working hours, rest days, how to calculate when a rest day should be allocated, how many what's the maximum hours of work we can make an employee work within 1 week. Now, those protections really deal with more of the lower wage workers, because these workers tend to do shift work or have to work 6-7 days a week. So that those protections are afforded to them. But there are also other provisions in the Employment Act which apply to all employees now, one of which will be actually really the termination clauses, which I will touch on slightly later, but just to bear in mind. So now we know that in Singapore, traditionally pro-employer, in the recent years, slightly more protections afforded to employees. But how exactly do you get workers in Singapore? Now, obviously, there is no issue if you hire all Singaporeans. But as a foreign company, obviously, you might need to send in some employees to train the local workers, or to have oversight or supervision at various levels, or due to their specialization, in the nature of their work. So in Singapore, we have, I'll generally put it as three categories of work passes that a company can obtain so that a foreigner can come to Singapore and work. So the first is an employment pass. So an employment pass is actually intended for skilled, educated workers like managers or executives. There's a requirement for salary. So in order to apply for an employment pass, that employee has to earn more than $4,500 a month, or more than 5,000 if it's in the finance sector. There is no quota applicable, so a company can get as many employment passes as it wants. Obviously, if it's granted by the Ministry of Manpower in Singapore, but it's renewed every 2 years. So every 2 years, you have to renew your employment pass for your workers. Now, the next level of pass is the S pass, which is for mid-skilled technical workers. So your technicians, for example, who earn 2,500 Singapore dollars and above. Now, there is a quota for this, which applies. This basically means that the company can only hire a certain amount of foreigners based on how much of the workforce is actually local. So Singaporean citizens or Singaporean permanent residents. Third one is a work permit. A work permit is only for certain industries. For example, for construction, manufacturing, processes, services, and only from approved sources. So the approved sources are generally for countries in the region who provide, for example, construction workers or service staff. So there are also quotas applicable for this, again, based on the strength of your local workforce, basically Singaporeans or Singaporean PRs. And as a result, you can see for the S pass and for the work permit, these two have applicable quotas and levies because you're basically taking away, in a sense, jobs from Singaporeans. So that's what the intention is supposed to be, which is why there's some protection there. There are other local protections as well. The first is a local qualifying salary. So this is tied to your existing Singapore workforce. And basically, the quota that you get for your foreign workforce is tied to how many Singaporeans or Singaporean PRs you employ. And for the Singaporeans and Singapore PRs that you employ, they must be paid a local qualifying salary. This means that there's a minimum that they must be paid in order for them to qualify as a number to be counted for your quota requirements. So this figure now, I think it's going to be $1,400 per month. So this means that, all Singaporeans and all Singaporean PRs in the company must be paid this sum of money, $1,400 each month, before you can actually even employ a foreigner. The next one is actually fair and progressive employment practices. In Singapore, there is actually a tripartite alliance made up of employers, employees, and unions, which have come up with something known as the fair and progressive employment practices. So in recent news, it was mentioned by our Prime Minister earlier this year that they will actually codify these practices into law. Currently, it's only guidelines, which don't have the strength of law, but is looking to making it into law so that any breach of it is governed by that law and it's also regulated by law. So these employment practices generally deal with advertising for jobs. You can't discriminate based on gender, ethnicity, marital status. It extends to handling grievance procedures, etc. So it's just basically a set of practices now intended to ensure that everything is fair for all employees, regardless of their gender, ethnicity. So that's the fair and progressive employment practices. The last one, which is the fair considerations framework. Now, this is important because, as I mentioned previously, the S pass and for the EP, so the employment pass and the S pass, before you actually hire that foreigner, you actually need to advertise locally in Singapore on a government portal for a certain period of time before you can actually even offer the job to a foreigner. So there are some exemptions that apply. For example, if it's a temporary short-term transfer of less than a month, or there's an internal corporate transfer, or I think now if the salary of the employee is going to be more than 20,000 Singapore dollars. So this is actually quite an important thing to bear in mind because this is a requirement by law. You have to advertise locally in Singapore for the same job on this portal for that period of time. If you do not comply with these requirements, the MOM, the Ministry of Manpower, will decline to provide you or to grant that pass that you need in order to bring in a foreigner to work in Singapore. So that's the fair consideration framework. Now, one other thing you might want to think about then, right? Because you've heard from me how difficult it may be to hire a foreigner in place of a Singaporean. Now, one way you can actually, I wouldn't say get around this, but one way you can actually manage this is actually to have a contract for service rather than a contract of service. So what's the difference here? Basically, one is an employee and one is an independent contractor. So if it's an independent contractor, then all the previous things that I mentioned would apply because they're not an employee. This is obviously more important now, given that remote working seems to be possible for most employees. And so if you're thinking, it'd be hard to get a work pass for somebody you need to work for, or not work for, someone you might need in order to supervise operations or to do a certain task for the Singapore company in Singapore, you can consider maybe remote working, and then you can have an employment agreement. That's fine. Or you can even just choose to have an independent contractor relationship, right, with someone who provides a service. Now, it's very difficult to tell you specifically what would be looked at by the courts to determine whether, is it really an employee? Are you sort of disguising an independent contractor as an employee? There are quite a few factors which can be looked at. For example, if you have the ability to hire or fire that person, if you have control over the job or his tools or his trade. For example, you provide all the equipment. These might be various indicia which point to the person being an employee rather than an independent contractor. So that's a bit of a touchy area, not so clear. You should also consider things such as taxes and presence. So even if you choose, okay, I'm going to have an independent contractor in another jurisdiction, or employee in another jurisdiction for that matter, you might consider whether the issue of you being considered to have a presence in the jurisdiction, so attracting tax consequences to be an issue that you should think of. The last one, really just monitoring your employment relationship. You should always ensure that that you are able to monitor what your employee is doing. This might be an issue if your employee is working remotely in Bali, out of a villa, for example. So you really have to think what are the requirements for this job. As an employee motivated, you need to give him a lot of oversight. If so, then maybe a remote working situation may not be the best situation for you. So now we have talked about how to build a workforce. How do you actually maintain a workforce? Just 2 quick points. The first, obviously, I think might be familiar to most of you, employee stock ownership plans. This is very typical for startups. They give you a low starting salary, but then they give you options to exercise, to buy stock. When you prepare an employee stock option plan or ownership plan, you got to start thinking about how do I incentivize the employee to stay for a period of time. So you can grant a plan which vests over maybe 4 years, 5 years, and each year the employee is allocated a certain percentage of shares. So that incentivizes the employee to keep staying with the company for a period of time. Another one about maintaining a workforce is restrictive covenants. So now these are your non-compete and non-solicitation clauses. So for your non-compete, this basically means that employee is not allowed to compete with you after he leaves your company for a period of time. I will not touch into the enforceability of these clauses, but it's just to share with you generally what some type of these clauses are. The other one is actually a non-solicitation, and I feel that this really is more important. 2 things: they can undertake not to solicit any employees after any other of their fellow employees after their employment, or not to solicit any of your customers after they've left your employment. So it's quite important to have, I think, these 2 clauses in your employment contracts if you feel that the employee has been able to build relationships with your fellow employees or your customer base. But obviously these have to go into your employment contract when the employee first signs it. It can't be added in as an afterthought. So that's something about maintaining your employment. Now the last point, termination of employment. So as I mentioned, in Singapore, it's at will. Basically, there are 2 ways to terminate an employee, to put it simply. One is with notice. That means in accordance with your contract, which normally will stipulate that the employer or employee has the right to terminate the employment contract with 1 month's notice or 2 months' notice. There are certain minimum requirements for notice under the Employment Act. But in general, I think most companies have 1 month, 2 months, and that's fine. That meets the minimum requirements. The second point is really more important. How do I terminate an employee without notice? This means that you're basically telling him that he's being summarily dismissed. And in Singapore, the one test, and there's only one test, is under the Employment Act, is for misconduct, right? So it's very important because now that the Employment Act applies to all employees in Singapore, if you were to terminate an employee for misconduct, you have to comply with various procedures. The Employment Act in Singapore, however, is a bit unhelpful on this point. It requires you to go through a period of due inquiry, but it does not explain what is the minimum requirement. What does due inquiry actually mean? There is some guidance from MOM. Basically, you have to give the employee due process, right? So he has to have an ability to state his case. You have to tell the employee what the charges or the allegations of misconduct are. And you also have to ensure that the tribunal or the persons hearing this disciplinary matters are impartial. In addition to that, there's a lot of case law in the last few years as well, which shed light on what the courts will consider due inquiry. So, for example, there was a recent case, I think, released earlier this year, or last year, where an employee was not told really of the allegations being made against him, and eventually, when he was told, he was not given any opportunity whatsoever to refute them. So they got the employee to come onto a call, and then they told him that these are the charges and allegations against you. But before he could respond, the call ended. I think he had to leave because he was feeling unwell. But the company never then followed up with an opportunity to give him the chance to explain. In another case, an employee was told to come to discuss, for example, in this case, I think unused leave before he was going to be terminated. But at the discussion on unused leave, actually it was an ambush, right? So then all the allegations of misconduct were thrown at him without any advance notice, and the court said that that's not a proper way to conduct a disciplinary process. So there are a lot of obstacles to be careful of when you actually do your disciplinary process. It will be very helpful if your company has a proper disciplinary process in place that all employees are aware of, so that you can actually then ensure that you meet these minimum requirements and don't fall foul of the Employment Act. So now we've dealt with hiring employees, maintaining employees, and terminating employees. So I think just in a nutshell, Singapore is pretty open to having foreigners to come and work, just that there are minimum requirements to be met. So you must be mindful of all the laws that apply to ensure that, when you do hire your foreign workforce to come in Singapore and work, they are able to do their job well and not have any issues with their work passes in the foreseeable future. And then with that, I think we will end our presentation. We brought you through the life cycle of a company, from how to set it up, what kind of companies to incorporate, how to fund your business, what kind of documentation you need, how to get your employees together, what happens at the end of the day if the company goes insolvent. Well, the counterparty goes insolvent, how to deal with that as well. And I think we will open the floor to questions. And I think Lena has joined on as well. So if you have any questions, please feel free to ask. Thank you very much.
Okay, thank you very much, Lynette and Matthew, for the very interesting presentation. We are going to open now a Q&A turn. So I ask the attendees, please, to feel free if you want to write any question in the chat. In the meantime, I have a couple of questions already here that I would like to ask you, either Lynette or Matthew. If I'm thinking of setting up my business in Singapore, which structure should I choose? What, either of you?
Okay, I think that's not going to be a straightforward answer. As I mentioned earlier, it really depends on what you're trying to achieve, the amount of capital you have, and at the end of the day, the decision must also be in terms of dollars and cents.
You have a little bit of echo, Lynette. You have a little bit of echo voice. I don't know.
Okay, is this better?
You have to.
Okay.
Now I think it's much better.
Is it better?
Yeah, much better. Thank you.
All right. Okay, I think, okay, this is better, right? Okay, sorry. So it really depends. At the end of the day, you need to do a holistic analysis, because I think in any business, it's always about dollars and cents. So you need to take into account the tax considerations. You need to take into account your workforce, how much it will cost to put people here, the cost of the employment passes and all of that, as well as the reporting requirements and the compliance, right? As I mentioned, you need to file tax returns, you need to have a locally resident director and all of that. So depending on the size of your business, how much money you're putting into it, the thing or the industry that you wish to enter into, the answer might be different. Now, bear in mind, I just say this, that the Singapore government has been quite encouraging in terms of certain industries, and there are certain exemptions or grants that they will support these industries to ensure that they come into Singapore and become, players in the Singapore market more. So it really depends. There's no straightforward answer.
Okay, very good. Thank you, Lynette. I have another question here. If I want to employ a worker in Singapore, can I provide that the governing law of the employment contract is something other than Singapore law?
Okay, I'll take this. That's an interesting question. Possibly. So just to repeat Fernando's question, they want to employ a worker in Singapore, but the employee is working in Singapore, but the governing law of the employment contract is something other than Singapore law. I think it's possible. You can have the employment contract governed by some other law. However, this does not mean that the Employment Act and the regulatory framework in Singapore will not apply, because at the end of the day, the employee is in Singapore, and there's jurisdiction over the employee and the company. I think the employment law regulatory framework will still apply to all the employees who are working physically in Singapore. So just to answer the question, you can put it. It may govern some other areas of the employment relationship which are not touched on by Singapore law, but in other aspects, so long as a specific issue, for example, termination, is governed by the Employment Act. I think the Employment Act of Singapore will still override and apply in that situation.
Okay, thank you, Matthew. One more question. If I know that my counterparty is facing financial issues, can I pressure him into paying me the debts owed?
Okay, so I think I'll take that question. So it's an insolvency issue. Your counterparty is basically insolvent, or is nearing insolvency, and you have a trading relationship and there's money owed. And obviously you want to get paid, right? So you pressure him into paying the money. You send him letters every day. You threaten him. Well, the answer is yes. You can pressure a debtor into paying you the amount owed. However, again, there's a however. There's some risk here, right? Because under insolvency law in Singapore, there are certain provisions for clawback. Basically, this means that you will claw back monies which the company paid out before its liquidation. And in specific, in this case, I think there's a doctrine of unfair preference. Basically, the company, by paying you, and I assume not paying any other companies, any other of its creditors, has given you an unfair preference. And if someone else finds out, and in liquidation, it comes out that, hey, they've paid Fernando, but they have not paid Lynette and Marissa, then Lynette and Marissa may actually make noise and complain to say that, it's Fernando has been unfairly preferred. He has been paid ahead of us when the company is insolvent. So at the point of time, there is certain risk of unfair preference, unless Fernando can say, I have shown that I give you a new trading facilities, or I'll continue trading with you, and it's very important that you keep trading with me, so you must pay me first. And the company says, yes, I must pay Fernando first, because the goods I buy from him are very valuable and the best sellers of things that I can sell further down the chain to generate more profits. So unless you can show some form of benefit and no desire to prefer Fernando specifically as a creditor, then yes, you can actually pressure someone into paying the debts owed first.
Okay, thank you very much, Matthew. Well, I think we have exceeded a little bit the time that we scheduled for the webinar. So we are going to end now. First of all, I want to thank very much Lynette, Matthew, for the very interesting presentation, to thank HELMSMAN Law Firm for your permanent support to our Chamber of Commerce, and to thank also all the attendees for your participation. I'm sure that this webinar has helped us to solve some of the doubts that we had about setting up a business in Singapore. And that would be then all for today. Thank you very much.
Thank you very much.
Everybody, have a good afternoon. Thank you. Goodbye.
Bye.